testified that he called her. So at every single stage, it passes the test, and it should be admittable under MRE 804B3.
The court had an opportunity to read People v. Taylor in its entirety at my lunch hour, and I agree with the people that it is admissible, so the suggestion is overruled and the statement comes in as well as People's Exhibit number 6.
Thank you, Judge. I just have basically, on the same subject matter, maybe one or two more questions for this witness, and then I'll be done.
Okay.
Yeah. There you go. Ready? Good afternoon, Ms. Rogers.
Hello.
Ms. Rogers, I showed you People's Proposed Exhibit 6 shortly before we broke to lunch. Do you remember this exhibit?
Yes.
And you said that this was a photograph that was shown to you among a series of photographs by the police. Is that correct?
Yes.
Okay. And you were able, and you picked this photograph out as somebody that you knew. That's what you testified to, right?
Yes.
Okay. And how is it that you knew this person?
He came over to the house before.
Okay. And did you associate this person with anything?
No.
So you recognized this person because you had seen this person previously?
Yes.
Had you also been told about this person in your conversations with Charles Cox?
Yes.
And what did he say to you? What did CJ say to you?
He said that he was the guy that was with him.
During the robbery?
Yes.
And you knew this person as living at a particular location. Is that an accurate statement?
Yes.
Where did you know this person as having lived?
I was thinking he stayed on Avondale.
Okay. And you told that to the police?
Yes.
And you also knew something about the physical characteristics of this person?
Yeah.
And what was that?
That he had like a nappy hair and dark-skinned it.
And anything else about his facial features?
He had like bumps.
And do you see this person in the courtroom today?
Yes.
This person that CJ told you that he was with during the robbery?
Yes.
And can you point that person out? Well, let me ask it. Let me go this direction with it. Is he wearing yellow as well?
Yes.
And he's further away from me than CJ?
Yes.
Okay. And for the record, the witness has identified defendant Darnell Young.
The record reflects the identification of Mr. Young.
And you told this to the police as well. Is that correct, Ms. Rogers?
Yes.
All right. Thank you very much.
Cross-examination on behalf of Mr. Cox.
Thank you. Good afternoon, Ms. Rogers.
Good afternoon.
Ma'am, you don't want to be here today to testify, correct?
Correct.
As a matter of fact, it's the Detroit Police Department that brought you here today, correct?
Correct.
Is it fair to say that they forced you to come testify today? Is it a yes or a no, ma'am?
No.
No what? They didn't force you to come testify?
No.
Okay. Did you tell the Detroit Police Department that you want to plead the Fifth? And that you don't want to testify, but then they threatened you that you would get in trouble if you don't testify today?
Judge, we object to that question on a couple of grounds. Number one is it's irrelevant. I mean, pleading the Fifth has nothing to do with this witness. And number two is it doesn't go to any part of her substantive testimony. It's basically just...
Judge, it's very relevant. It goes to the voluntariness of this, and I have a right to cross-examine her on that. They might not like the question I'm asking, but that's not how we view cross-examination. In this state, cross-examination is to be construed very liberally, and to allow defense counsel to be able to elicit testimony from this witness.
On relevant matters, why do I care if she's here voluntarily or involuntarily?
Because it has to do with, well, not if that's,
I mean, I could tell all day that she's hesitant to testify,
okay,
but, I mean,
well, I'll ask it differently.
okay.
Ma'am, isn't it true that what you told the police when you were interviewed, not everything you told them was correct? Isn't that true?
No.
So everything you told them was true?
Yes.
Okay. You testified that Mr. Cox is the one who called you and began to speak with you regarding this incident, correct?
Yes.
Are you sure that's true?
Yes.
Okay. What's your phone number that he called you on?
Judge, I will object to, first again, the relevance of that, and second of all, the witness shouldn't have to answer that question, particularly in this setting.
Well, Judge, I want to know what phone number she called on so I can be able to find out whether she's the one who called him or he called him. I can't do discovery if this individual cannot testify to that. So that's why I'm asking it.
You can do discovery if she doesn't testify to it. It's called a discovery order, counsel. You can put that request in the discovery order, and they'll give the telephone number. But what I'm not going to do is make this witness tell her telephone number to a courtroom full of people and to the news media.
Okay.
I'm not going to do that.
Well, Judge, with all due respect, we've cleared the court before for other questions, and I would ask the court to clear the courtroom for this question.
No, I've not cleared the courtroom for any question, and for this question, she doesn't have to answer the question. However, I will be more than happy to sign a discovery order indicating what phone number she is claiming that the defendant called her on. I will be more than happy to sign that as a conclusion of the matter if it's necessary.
Thank you, Your Honor.
You're welcome.
Ma'am, isn't it true that you told the police before that you're the one who called Mr. Cox to discuss this incident?
No.
Okay.
Ma'am, you gave a written statement to the police, did you not?
Yes.
And that was on the date of January the 11th, 2016, correct?
Yes.
And you reviewed the statement and you signed it, did you not?
Yes.
And did you not put in it that I called Charles and I asked Charles, did you call that man?
I don't recall.
Well, showing you your statement, refresh your memory.
That was a question, ma'am.
Oh, yes, please.
Can I approach, Judge?
You may.
You see that? Ma'am, did you put that in your statement?
Yes.
So why did you lie today and say that Charles is the one who called you first?
The objection as to the characterization of that, the usage of lie, Judge.
Judge, I can use that. There's plenty of case law that says I can use that. This is cross-examination. She's under oath. She's here to tell the truth. She's told us that Charles is the one who called her. In her statement, she told the police that she called Charles. There is no other characterization but the fact that she lied. She's under oath.
That's not,
Well,
that's,
there is another characterization. There are several other characterizations.
Okay.
However, the objection is overruled.
Why did you lie to the police?
I didn't.
I'm sorry?
I didn't lie.
Okay, so are you lying then today when you say Mr. Cox is the one who called you?
No.
So it's both. You called him and he called you, correct? That's your answer?
That is my answer.
Okay.
Ma'am, when did you report your gun as being stolen? What date?
I think the 23rd.
Of December 2015? Is that a yes?
Yes.
And did you report that to the City of Inkster Police Department?
Yes.
When did Mr. Cox call you, or did you call Mr. Cox and speak about the video that you watched on television? What was the date of that?
I don't really recall.
You can't even give us an estimate of how many days after the incident?
No.
Okay. When you watched that video on the television, you were not 100% that that was Mr. Charles Cox, were you?
Yes.
Yes, what? You were 100%?
Yes.
Okay. And you were not able to see his face, correct?
Correct.
And what's so special about that hoodie, besides the fact that it's gray, that led you to know that that's your hoodie?
Because I know my clothes.
Because you know your clothes. Ma'am, did you know about this murder prior to it happening? Is this how you know all this information?
No.
You wouldn't tell that to the police, would you? Did I yes or no?
No.
Because you wouldn't want to get in trouble, correct?
Correct.
Regarding this gun, you never saw Charles stealing that gun, correct?
No.
Okay. So your gun is missing. You watch on TV this video of the murder. You're 100% sure that that's Charles Cox, who is your boyfriend, and the first thing that you do is contact the police and report it, correct?
I reported my gun stolen.
Okay. But what I'm talking about is you call the police and say, hey, Charles Cox, my boyfriend, I just saw him on TV, he just killed somebody. You did that, didn't you?
No.
As a matter of fact, it was the Detroit police who first contacts you, correct?
Correct.
And they tell you that we want to talk to you because we got a report from the city of Inkster regarding your stolen gun, correct?
Correct.
And that's how all the conversation begins regarding Mr. Charles Cox, correct?
Correct.
And when you went to be interviewed by the Detroit police, prior to them asking you some questions, they had given you some information that they are there to investigate Mr. Charles Cox and the killing on Christmas Eve, correct?
Correct.
Now, ma'am, you were also interviewed by the Wayne County Prosecutor's Office. Isn't that true?
Correct.
And they brought you to the 12th floor in this building?
Correct.
January 11, 2016. Does that refresh your memory?
Correct.
Okay. And you were asked a question regarding the fact that in looking at that video, you can't be 100% sure that it's him. Is that what you told us? Do you recall what your answer was? Page 20. Do you recall what your answer was? Did you tell him back then that, oh no, I'm 100% sure that's Charles Cox?
Yes, I did say that.
Okay. What if I told you, ma'am, your answer instead was because I can't see the, his face? That was the answer that you gave. Wasn't that your answer back then?
I don't recall.
Now, you said that allegedly, or let me ask you this. The incident happens, you watch it on television, Mr. Cox calls you on the telephone, or you call him on the telephone, correct? One of the two occurred?
One of the two.
Okay. Between those two events, did he ever come to your house in Inkster?
Yes.
Okay. When did he bring these alleged items, such as the video games and this Batman toy into your house?
I don't know. I don't know the dates or nothing.
Okay, but you saw him bringing that, correct?
Yes.
And did you ask him where he got those items from?
I think I did, yeah.
Okay. And you knew at that time that these were items that belonged to somebody who was murdered, correct?
After, when he told me, yeah.
Well, when did he tell you? When he brought them to your house?
Yeah.
Okay. And you didn't want those items in your house, correct?
No.
And you called the police and told them there were some items that belonged to a person that was murdered. You did that, didn't you?
No.
Ma'am, you said you purchased your gun about 3 months prior to this incident?
Yeah, it was during, I think it was in June or July, something like that.
Of what year? 2015?
Yeah.
And you bought the gun to be used in the murder of this case?
No.
Ma'am, when you reported your gun missing to the
City of Inkster Police Department, did you tell them that you suspect that it's Charles Cox who stole your gun?
No, yeah, I told one of the officers. He asked me,
Inkster Police or Detroit Police?
Inkster.
Okay.
Ma'am, when you made your statement to the police, were you under the influence of any alcohol?
No.
How about drugs?
No.
Police ever threaten you to get 20 years in jail if you don't come testify today?
Yes or no?
No.
I have nothing further at this time, Judge.
Cross-examination on behalf of Mr. Young.
Ms. Rogers, you said you had a conversation with Mr. Cox about this incident. What was the first date that you had this conversation?
I don't recall the date.
How about the second conversation you said you had?
I don't really remember.
You don't remember? Well, wasn't it December?
It was during December, but I don't know the exact date.
Okay. How much time went by between the first conversation that you had with Mr. Cox and the second conversation that you had with Mr. Cox?
You said what?
How much time went by between the first conversation you had with Mr. Cox and the second conversation that you had with Mr. Cox?
I don't know. I don't know.
Okay. You said on direct examination that Mr. Cox told you about this second person, correct?
Correct.
Was it in the first conversation or the second conversation?
I don't know.
So you don't know which conversation it was in that Mr. Cox told you about the second person, correct?
Correct.
You would agree with me that the first time you ever talked about a second person is when the police talked to you, correct?
Correct.
You didn't talk to Mr. Cox about a second person at all, correct?
Correct.
Thank you. Further question?
There's nothing funny in my courtroom. Nothing. Redirect.
Yeah. Did you hear that last question that counsel asked you?
No, not really.
Well, then let me ask it again, Judge. If that's the case. You did not hear my last question, correct?
Correct.
Okay, my question to you is, you did not have a conversation with Mr. Cox at all about a second person, correct?
Correct.
Thank you.
Did Mr. Cox talk with you about anybody else that did the robbery with him? Did CJ at any point in time talk with you about anybody else that did the robbery with him? Do you understand my question?
Mm-hmm.
Let me ask you this. You remember Exhibit 6? Can I approach the witness, Judge?
Yes.
I just want to remind you, because you probably don't remember, this exhibit, right? So you remember Exhibit number 6.
Mm-hmm.
And I had asked you, when I first was doing my examination with you, whether or not you identified this person to the police. And do you remember telling me that you did?
Yes.
Okay. And you identified this person as the person that was with Mr. Cox during the robbery, right?
Yes.
And so what counsel was just asking you is...
Judge, I'm going to object to the mischaracterization of the testimony that she identified him as the second person in this robbery, because if we're looking at the same picture, Judge, her answer was, I think he could be the second person in the video.
Yeah, well, that's not my question.
Well, but what he just told her, you identified him as, isn't it true that you've identified him as the person as the second person who was involved in this robbery with Mr. Cox? That's not what's on the sheet.
Yeah, Judge, I asked her on direct examination if she identifies this person as the second person that was with Mr. Cox during the robbery. And she, on direct examination, said yes. I'm not asking her what specifically was put on this piece of paper. I'm just bringing the witness back to direct examination where she was asked, is the person on Exhibit number 6 the person that was with Mr. Cox during the robbery? She said yes. And then my question now is, how do you know that?
Judge, I could be wrong, but I thought the question was, when he showed her this picture, didn't you tell the police that this was the second man, etc., etc.? And that's not what she told the police on this sheet.
Right, joint counsel in this argument.
That's not his question. He didn't say, did you tell the police, nor did he say, did you write on this paper or did somebody write on this paper? His question was, did you identify this person whose picture is on this paper as the second person in the robbery? That was his question. I'll allow it.
Okay. So, Ms. Rogers, the person in Exhibit number 6, did you identify this person as the second person in the robbery?
Yes.
And how is it that you know that this was the second person in the robbery?
Charles, he told me.
Charles told you. Okay. Now, when you were being asked questions by one of the defense attorneys about your interview with the Wayne County Prosecutor's Office, do you recall being asked those questions?
Mm-hmm.
And he was referring to a transcript of that interview. Do you recall that?
Yes.
Okay. And he asked you whether or not you told the Wayne County Prosecutor's Office in this interview whether you were 100% sure or not as to seeing Charles on the video. Does that make sense?
Correct.
Okay. Do you recall exactly what you said during this interview with the Wayne County Prosecutor's Office?
No. Might
seeing a portion of the transcripts refresh your recollection as to what you said to the Wayne County Prosecutor's Office?
Yes.
Can I approach, Judge?
You may.
Okay, I'm showing you transcript pages 19 and 20. If you can review these to yourself, please, for a moment. Did you have a chance to read both pages?
Yes.
Does that help refresh your recollection?
Yes.
So when you were asked who it is on the video that you can't say for certain who it is, was that question about Charles Cox or was that question about Darnell Young?
Charles Cox.
It was about Charles Cox? Is that what you took that to mean?
Just
Yeah.
asked and answered.
Okay. Do you recall being asked the question, let me just clarify, when you said that he was the one that he was with, when he was telling you the story about the carjacking and murder, and you answered hum, is that your answer to that question?
Mm-hmm.
And you recall being asked the question next, did he tell you that this guy, this young guy that you identified in exhibit number 4 was in fact the guy that he was with during the robbery and carjacking? And you answered yes. You recall that?
Yes.
And then you recall being asked the question, okay, so that's what Charles himself told you, and you answered yes. And you were asked the question, that's who he was with that night, and you answered yes. You recall these questions and answers?
Yes.
Okay, then the very next question you were asked is, in looking at the video, you cannot be 100% sure that it's him. Is that what you told us?
Yes.
And you answered, because I can't see that you know his face. So are you talking about Charles Cox or about the person that Charles Cox told you he was with?
Judge, once again, objection, asked and answer. He might not like the answer, but you can't go back into a transcript. What is he using it for purpose? Is he trying to impeach her with it? You can't just read a transcript into the record just because you want to read it. He asked her, he showed her the 2 pages and asked her, who were you talking about? She said Charles Cox. He doesn't like the answer, so what is he going to do now? Trying to change her mind?
I'm not trying to change your mind, Judge. I'm going over questions and answers with this witness. It's substantive evidence from this investigative subpoena. And, this witness, I don't think she understood the question exactly, and it's not like I'm going over this over and over again. I would ask the court for just a little bit of leniency and allow her just to answer this question.
Judge, this isn't about leniency. She looked at the 2 forms. She looked at the page. She read them. He asked her a question, who were you talking about? Charles Cox. So you can't try to get somebody to change their answer by trying to read more to them and say, why don't you change your answer? Because pretty much that's what he's trying to tell her to do.
Thank you. So, Ms. Rogers, very simply, when you said, because I can't see that you know his face, were you talking about CJ or were you talking about the person that he was with?
The person that he was with.
Okay. And when it comes to CJ, now you've known CJ for how many years?
17.
Okay. And you've been in a relationship with him for how long?
4 years.
And you've been living together for how long?
Going on 4.
Okay, so when it comes to CJ, were you 100% sure that you saw him in the video?
Yes.
Okay. Now, do you remember being asked on cross-examination the question about the police coming to you rather than you going to the police?
Yes.
When the police came to you, what was the investigation? What did they say they're investigating?
My gun.
Your gun. They didn't say they were investigating the murder of Anthony Tolson.
No.
All right, finally, at the very beginning of cross-examination, you were asked questions about you calling CJ, CJ calling you. Do you recall those questions?
Yes.
Now, you just said, once again, how long you've known him and the relationship that you two have been in. I assume you talk to him all the time, right?
Yes.
And he calls you all the time, right?
Yes.
And you don't keep a log specifically as to who calls who when, do you?
No.
Thank you very much.
Ma'am, you didn't see the individual on that video that's wearing a gray sweatshirt. You can't see his face either, correct?
No, I can't.
Okay. And this gray sweatshirt that you want us to believe is yours has no special markings on it that you can identify, correct?
Correct.
All it is a gray sweatshirt, correct?
Correct.
And when you came and gave a statement to the police, they asked you if you know why you're here today, correct?
Correct.
And what was your answer?
About my gun?
Okay. Did you say anything else besides about my gun?
No.
Do you recall saying about my gun and about what happened Christmas Eve, the murder?
Oh, yes. I
Okay,
do.
so you knew why you were there. It wasn't just your gun, it was also the murder, correct?
Correct.
And that's information that the police told you as to why you're there prior to starting to interview you, correct?
Correct.
I have nothing further at this time, Judge.
Now, my last question to you on cross-examination was that CJ did not tell you Darnell Young was involved in this case, right? And your answer was yes, correct?
Correct.
Okay. So now, you testified in investigative subpoena on January the 11th, 2016. You understand that sworn testimony, correct?
Correct.
Okay. You testified that CJ did tell you about Darnell Young, correct?
Correct.
Okay. You also testified today on direct examination that CJ did tell you about Darnell Young being involved in this case, correct?
Correct.
And you also told us just a few minutes ago that CJ did not tell you about Darnell Young in this case, correct?
I don't recall.
Oh, you don't recall my last question to you before I stood up here on recross? You remember I asked you, isn't it true that CJ did not tell you about Darnell Young being involved in this case? And your answer was yes. You remember that?
Yes.
Now, that was the truth, wasn't it?
Can you repeat your question again?
Isn't it true that CJ did not talk to you about Darnell being involved in this case?
No.
That's not true. Okay, so were you being truthful when I asked you that question, the last question I asked you on cross-examination, when you said, yes, CJ did not tell you about Darnell being involved in this case? Were you being truthful then?
Yes, I was.
No further questions.
Can you redirect?
No, Your Honor.
Okay, thank you, ma'am. We may step down.
Judge, no more, well, here, let's,
Face forward. Mr. Cox. Face forward.
Judge, no more witnesses for the people. We would move for a bind over as charged in all counts.
Judge, on behalf of Mr. Cox, we have no witnesses, and it is a question of fact at this time, Judge.
Your Honor, on behalf of Mr. Young, we have no witnesses either, and we leave it to the court's discretion.
Okay. The court has had an opportunity to consider this Charges against Mr. Cox and Mr. Young, the testimony of the witnesses, the exhibits of the people. There were no stipulations. Yes. The stipulations of the parties.
Yeah, there were the three stipulations, Judge, were to the medical examiner's testimony, to the identification of Anthony Tolson as the deceased, and to the... That's right.
Okay, yes. The stipulations of the parties. And the court makes the following determination with respect to the testimony that has gone forth over the last 2 days. Of course, the evidence before the court was that Mr. Tolson was shot while sitting in his vehicle in front of a store. According to the witness, Mr. Searcy, Mr. Tolson went into the store with his close friend before heading home to celebrate Christmas with his children. Mr. Searcy went into the store to make a purchase, and while he was in the store, someone ran into the store stating that two men had just shot someone in the parking lot and had driven off with the vehicle. Mr. Searcy subsequently went outside of the store where he was horrified to see his friend laying on the ground, and the vehicle they had arrived in was gone. This act was recorded on at least 3 video cameras in the areas and submitted as People's Exhibit number 2. Those videos revealed that 2 individuals approached Mr. Tolson's vehicle and without any regard for his life shot him 3 times according to the medical examiner's report, and then drove off with his car. Mr. Young's aunt Kiera Strickland testified that he confessed to her that he was the one that had committed this absolutely horrible, unprovoked, senseless shooting of Mr. Tolson in cold blood in the chest after his bro decided that they could get money from Mr. Tolson's rims, so they decided to rob him. He ordered him to get out of the car, and when he said no, they decided that their desire to get something from nothing was greater than or more important than human life itself. Mr. Young callously and without regard for life shot Mr. Tolson in the chest. Mr. Cox ruthlessly and with total and complete disregard for human life approached Mr. Tolson's car, immediately shooting through the front windshield, and according to the medical examiner's report, shooting him at least 2 times. Nakia Rogers testified that Mr. Cox confessed to her that he callously, with grave indifference and without any regard for the life of another human being, shot Mr. Tolson to help his boy, who was himself robbing Mr. Tolson of what rightfully belonged to him, a thought process that is completely warped and flawed in its application. Not only did the evidence bear out that Mr. Cox and Mr. Young's attitude about human life is callous, but their conduct in this court, Mr. Young's outrageous outburst in the hall, clearly manifests that there is some deep-rooted issues that have been left to fester in their minds and in their hearts. Just as the court noted in the Taylor case, which was presented to this court during arguments on the admissibility of a co-defendant's statement against another defendant, these defendants had an unabashed willingness to kill Mr. Tolson for some rims, weed, and video games. How awfully outrageous is that? Clearly, the testimony in this case on this record is sufficient to create a question of fact. For a trial of fact, there is probable cause to believe that the crimes as charged in the information were committed. They were committed in the city of Detroit, and they were committed by Mr. Charles James Cox and Mr. Darnell Jean Arthur Young. Therefore, they are both bound over to the Wayne County Circuit Court for further proceedings on the information. Arraignment on the information is February the 8th, 2016 at 9 o'clock a.m. Are there any other issues to this court?
Yes, Judge, may we address the issue of bond? Judge, I'm requesting that bond be set. Right now, it's at remand. You can set a high bond.
You can address bond.
Right. You can set a high bond, and that's fine, but we're asking for a bond to be set, because right now it's at remand. We're asking for a monetary value rather than just remand.
Why would I do that?
Because I don't think remand is appropriate. I think we need to have a monetary bond. Because as of now, with all due respect, it's only a question of fact. But the point is, you can set the bond as high as you want, but it needs to be a monetary bond rather than just remand.
Would you like to respond, Charles?
Remand is appropriate for murder in the first degree, Your Honor. I don't think I need to say more.
Remand is more than appropriate. The court is aware that as Mr. Cox sits here today, he is by law presumed innocent. However, in consideration of bond, there are a number of things that the court has to take into consideration. The likelihood of conviction, the callous and heinous nature of the allegation that's set before it. And this was just horrible. You know, it's just horrible. It's just absolutely horrible that a man would be sitting at a store waiting to go celebrate Christmas with his kids, and because he had the nerve to purchase some rims that he thought would make his vehicle look nice, that he was targeted for a crime. It's horrible, horrible. And then for him to dare to try to fight back and to be shot in the chest, and then according to the video that I saw, your client is the one who, without provocation, just ran up to the car and shot through the window, killing the victim. It's absolutely horrible, and remand in this instance on these facts is way more than appropriate. Bond remand.
Thank you, Judge.
Remanded.
Thank you.
Would you like to address that?
Absolutely not.
Okay, then we're all set. We'll see you on February the 8th, 2016 at 9 o'clock a.m.
You know what, here, you check this. You're right, I am. You're absolutely right. I'm gonna wear it on how much you do.
What are they? But these are good.
All right, you're right, I am.